This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast. Today, we're doing a deep dive into, the often complex world of UK venture capital documentation. Specifically, we're focusing on the British Private Equity and Venture Capital Association, that's the BVCA, and their model documents for Series A investments.
Yeah, and this is really key stuff for, many of you listening in Luxembourg. If you're advising on or maybe involved in cross-border deals into the UK, getting your head around this framework is, pretty essential.
Absolutely. So our mission today is really to unpack this standard suite of documents. We want to guide you through the core legal ideas behind them, walk you through the typical process, flag up the key negotiation points you're likely to hit.
And crucially, touch on the latest updates. We've seen quite a few recently. The aim is really just to give you the context you need to navigate these UK VC deals, maybe with a bit more confidence.
Sounds good. So let's maybe use the classic 5 Ws and the H as our roadmap for this. Where should we start?
Okay, let's do it. First, what are the core legal documents in a UK Series A? We're talking subscription agreement, shareholders agreement, articles of association, and that initial term sheet.
Right. Then why? Why are these BVCA models so dominant in the UK? We'll look at their role in standardizing things, trying to cut costs, speed up deals, and the thinking behind the investor protections and governance baked into them.
Then who? Who are the players? The company, investors, founders, existing shareholders.
Yeah.
What are their rights, their obligations within these agreements?
And when? When do these docs actually appear during a Series A round, from that first handshake over terms right through to closing the deal?
Definitely. And where are the legal contexts? So UK legal system, English law usually governing, and those public filing bits at Companies House.
And finally, how? How do they all work together? How are they negotiated? How do they stay current with BVCA updates and market practice? Including, all unnecessary corporate paperwork.
That's the plan. It covers a lot of ground.
It does. Okay, let's jump in. Understanding the UK VC landscape and this BVCA framework. The BVCA is the main industry body, yeah? What's their main goal with these model docs?
You got it. They're the key trade association. And their big push with these models is standardization. Really, it's about making the whole legal process smoother, cheaper, and faster for everyone involved. Efficiency, basically.
Kind of like the NDCA docs in the U.S.
Very similar idea, yeah.
Mm-hmm.
Building a common baseline to save reinventing the wheel every single time.
But these specific BVCA Series A docs, they're not for every startup deal, are they? Who are they aimed at?
No, that's a really important point. They're specifically designed for early-stage UK companies doing a proper Series A round, usually with professional fund investors coming in. The BVCA themselves say they're not suitable for earlier seed rounds.
Why not? What's different about seed?
Seed rounds tend to use much simpler, shorter form documents. Think term sheets, maybe a simple subscription agreement. You typically only see this full, complex BVCA suite come in at the Series A stage when the stakes are higher, the investment is larger, and investors demand more detailed protections.
So they signal a step up in complexity and professionalization.
Exactly that. And because they're widely used and backed by the industry body, they've gained real traction and acceptance in the UK market. It's what people expect to see.
Okay, now this is where it gets interesting, especially for listeners perhaps more used to civil law systems. These aren't static templates you just download, right?
Not at all. That's a key feature. They're dynamic. The BVCA's legal committee and a working group review and update them periodically. We saw significant changes in Feb 2023 and more updates around February-March 2025.
And these updates respond to real-world stuff, like court cases or new tech trends.
Precisely. A classic example was the update after the Dina Nudge court case, which frankly surprised a lot of people with its interpretation of share rights clauses. The BVCA reacted pretty quickly to clarify the drafting.
And you mentioned AI warranties being added.
Yeah, totally new warranty schedule covering AI. It shows they're trying to keep pace with technology and market risks. For anyone working with, say, codified civil law frameworks that change less frequently, this constant evolution is a major difference. These are living documents.
So keeping track of the latest versions is crucial for advisors.
Absolutely. You need the latest version. You need to understand why things were changed and how market practice is actually using them. It's ongoing homework for Luxembourg professionals dealing with UK deals.
But even though they're model docs, they're not set in stone. Negotiation is still key.
Oh, absolutely not fixed. They provide a standard structure and language, which is great for efficiency, but they have loads of optional clauses. And key commercial terms, investor rights, vetoes, liability limits are always heavily negotiated. It's finding that balance between using a standard template and tailoring it to the specific deal, the specific leverage between the parties. Legal review and negotiation are still 100% necessary.
Okay, let's zoom in on the documents themselves. You mentioned 4 main ones in a Series A package. How do they relate?
Yeah, think of them as working together like a matched set. You've got the term sheet, the subscription agreement, the shareholders agreement, or SHA, and the Articles of Association, the AOA. Each plays a specific part, but they're drafted to be consistent.
Can you quickly recap the main job of each? The term sheet first?
The term sheet is like the blueprint, usually non-binding, apart from maybe confidentiality and exclusivity, but it outlines the main commercial and legal points agreed: upfront valuation, investment size, board seats, key investor rights, sets the direction for everything else.
And the subscription agreement?
That's the one that makes the investment legally happen. Investors agree to put money in and subscribe for shares. The company agrees to issue them. And crucially, it contains the company warranties and any conditions that need to be met before the money flows.
Then the shareholders agreement, SHA.
The SHA is a private contract. It governs the ongoing relationship between all the shareholders, new investors, founders, maybe existing shareholders, and the company itself after the investment. This is where you find the nitty-gritty on governance, decision-making vetoes, information rights, rules on selling shares like preemption, tag-along, drag-along.
And finally, the Articles of Association, the AOA.
The AOA is the company's public rule book, its constitution. It has to be filed publicly at Companies House. It sets out internal rules, director powers, meeting procedures. But most importantly for VCs, it legally defines the different share classes and their core economic rights voting, dividend priorities, and what happens to their money first in an exit or liquidation. And it must comply with the UK Companies Act of 2006.
So the SHA kind of builds on the AOA, adding more private detail.
Exactly. The AOA sets the fundamental constitutional rights, often the economic ones, and the SHA adds layers of contractual agreements on top, especially around governance and share transfers.
I think you mentioned the BVCA structure now keeps the subscription agreement and SHA separate.
Yes, that's a relatively recent change in the models, and quite helpful. They used to sometimes be combined. Separating them makes the SHA work better as that living document we talked about. When new investors come in later rounds, they just sign a deed of adherence to the existing SHA, rather than having to deal with a complex, combined document containing historical investment terms.
Makes sense for growing companies.
Yeah, very practical, especially for those multi-stage investments that Luxembourg funds might be involved in.
Going back to the term sheet, even if it's mostly non-binding, how important is it really?
Hugely important, strategically. Even non-binding terms create a strong commercial and, frankly, psychological baseline. Trying to fundamentally renegotiate points agreed in the term sheet later in the process is really difficult and can damage trust.
So getting legal advice at the term sheet stage is crucial. Before you sign anything.
Highly, highly recommended. You really need to understand the implications of what you're agreeing to, even in outline form, before the expensive process of drafting the full legal documents begins. It sets the course for the whole deal.
Okay, useful context. Let's shift gears a bit. For our listeners in Luxembourg, some UK legal concepts might feel a bit different from a civil law perspective. Let's start with basics. Shares and equity in the UK context.
Sure. So shares are the specific units of ownership, like building blocks, each carrying defined rights. Equity is the broader term for the overall ownership stake. A key feature in the UK is the ability to create different classes of shares, typically ordinary shares for founders' employees and preference shares for investors with quite distinct rights for things like voting, dividends, and return of capital. This tailoring is fundamental to UK VC deals.
And the words around liability, warranties, representations, guarantees, can you clarify those? They often get mixed up.
They do. Okay, a warranty is basically a contractual promise about a state of affairs at a particular point in time. So the company warrants, for example, that it has no ongoing lawsuits. If that turns out to be untrue, the remedy is usually damages for breach of contract, often based on how much the breach reduced the value of the shares.
Not a representation.
A representation is a statement made before the contract is signed, usually to encourage the other party to enter into it. If a representation is false, a misrepresentation, the remedies can be broader, potentially including unwinding the contract, rescission, or damages. In VC deals, the subscription agreement often explicitly states that the warranties are also to be treated as representations, trying to give investors access to those potentially stronger remedies.
Okay, and a guarantee. How is that different?
A guarantee is typically a promise to pay someone else's debt if they default. It's a secondary obligation. The crucial thing here is that a warranty in a VC context is a statement of fact about the company now. It is absolutely not a guarantee of future performance or that the company will be successful or that its products are perfect. Very different concepts.
That distinction is really important. What about indemnities? They often appear alongside warranties.
Right. An indemnity is different again. It's a contractual promise to cover a specific, identified potential loss or liability. Say, during due diligence, you uncover a specific tax risk. The company might give the investors an indemnity promising to pay them back, pound for any cost that arises from that specific risk.
So it's much more targeted than a warranty.
Exactly. Warranties give broad cover over the general state of the business. Indemnities are used to allocate risk for specific, known issues. The rules around claiming under an indemnity are also different, often simpler, direct recovery, without the same rules about mitigation or remoteness of loss that apply to warranty claims.
Okay, broad versus specific. Got it. Now, the UK's legal system is based on common law principles. How does that feel different for someone used to Luxembourg's civil law?
The biggest difference is the role of judges in case law. In common law, court decisions, precedents, are a primary source of law, alongside statutes passed by Parliament. The principle of stare decisis means decisions of higher courts bind lower courts, so the law evolves through interpretation in real cases.
Like the Dinaj case you mentioned.
Exactly. That case directly changed how people understood standard contract clauses, and the industry had to react. Another principle is caveat emptor buyer beware. Warranties and indemnities are the contractual tools investors use to push back against that principle and get assurances from the company.
What about the concept of good faith? In many civil law systems, there's a broad duty to act in good faith when performing contracts. How does that work in English commercial law?
This is a really significant difference. Generally speaking, English contract law does not imply a broad, overarching duty of good faith in commercial contracts. The courts expect parties to look after their own interests and rely on the explicit, written terms of the agreement.
So if it's not written down clearly,
you probably can't rely on it. This drives the need for very detailed, precise, and comprehensive drafting in English law contracts. You have to spell everything out because there isn't that safety net of implied good faith to fill the gaps, unlike in many civil law systems. It explains why UK agreements can seem so long.
that's a fundamental mindset shift, and those entire agreement clauses you often see.
They reinforce that point. They state that the written contract represents the entire agreement between the parties and supersedes any previous discussions, emails, drafts, or understandings that aren't explicitly included in the final document. It basically draws a line under pre-contract negotiations.
And what about phrases like best efforts versus reasonable efforts or endeavors?
Yeah, these pop up, defining the level of effort someone has to put into fulfilling an obligation. Best efforts is generally seen as the higher standard, potentially requiring significant expenditure or acting against your own commercial interests. Reasonable efforts is usually less onerous, more about doing what's commercially reasonable in the circumstances. But honestly, their meaning can be quite fact-specific and debated. So often, the better approach is to draft precisely what actions need to be taken, rather than relying solely on these potentially ambiguous phrases.
Okay, that's a great grounding in some key UK concepts. Let's dive deep into the subscription agreement now. This is the engine room of the investment, right?
Absolutely. This is the document where the investors legally commit their funds and the company commits to issuing the shares.
Who are the key parties signing on the dotted line?
Primarily, it's the company itself, because it's issuing the shares, and the investors who are subscribing for them.
What about the founders? Do they sign? Do they give warranties?
That's evolved a bit. Historically, founders might have given quite extensive personal warranties directly in the subscription agreement. But the market trend, certainly reflected in the current BVCA models, is for the company to be the main warrantor. Founder liability tends to be less direct now, maybe limited to specific areas or handled through their employment contracts with the SHA. It's definitely something founders need to be clear on regarding their personal exposure.
So why is this document so critical? What's its main purpose?
It does several key jobs. It legally binds the investment commitment. It contains those crucial warranties, the statements about the company's condition. It sets out any conditions precedent, CPs that need to be met before the deal actually closes. And it defines the mechanics of the share subscription and any limitations on liability for warranty breaches.
And when does it get signed in the process?
Typically, it's signed after the term sheet is agreed and the main due diligence is done, usually signed right at or sometimes just before the closing meeting when the funds are transferred.
And the contents cover, well, the mechanics, the price, the shares, the warranties.
Exactly. It specifies the investment amount, the price per share, the number and class of shares being issued. It details how the investors apply for shares and pay, and the company's obligation to formally allot them and issue certificates. It contains a long list of warranties and, importantly, the clauses limiting the warrantor's liability if those warranties are breached. And it sets out the practical steps for completion.
Governed by English law, obviously, for a UK company.
Invariably, yes.
Let's break down some core clauses. Conditions precedent, CPs. What are typical examples? Things that must happen before the deal is locked.
Right. These are hurdles that need to be cleared or formally waived before the investors are obligated to invest. Common ones are getting shareholder approval for the new articles. Maybe key third-party consents, like from a major customer or IP licensor, ensuring founders have signed new service agreements, getting regulatory approvals if needed. The BVCA model lists common CPs, often making them optional for negotiation.
And the subscription and allotment mechanics, how the shares actually get issued.
This part sets out the precise procedure. How investors formally apply for shares, how they pay the subscription money, and the company's obligation to then formally allot the shares on its books and issue share certificates once the money is confirmed. The BVCA models now offers some alternative simplified completion mechanics, maybe trying to speed things up.
Simplified sounds good, but any downsides?
Well, the BVCA themselves add a health warning. Simplified mechanics might offer slightly less protection, particularly for the company, if, say, an investor doesn't actually send the money after signing but before formal allotment. It's a trade-off between efficiency and risk that the parties need to consider.
Okay, let's talk warranties. You said these are statements of fact about the company. What areas do they usually cover? It sounds like a long list.
It usually is quite comprehensive. It's a key part of the investor's diligence confirmation and potential recourse. Typical areas covered are the company's legal status and corporate records, its share capital structure, accuracy of its accounts, ownership of assets, intellectual property, material contracts, employees, any litigation or disputes, tax compliance, regulatory compliance, data protection. The list goes on. The exact scope is always negotiated.
And the company giving these warranties needs some protection too, right? That's the limitations on liability.
Exactly. No company wants unlimited liability for breaches. So you negotiate limits. Standard ones include an overall cap on total liability, often linked to the investment amount, for example, 100% of funds invested, time limits for bringing claims, maybe 12, 24 months for general warranties, often longer for tax, de minimis thresholds, so investors can't claim for tiny amounts, and aggregate thresholds or baskets, meaning the total value of claims has to reach a certain level before the investor can recover anything.
And you mentioned earlier a crucial escape hatch. Liability is excluded for things fairly disclosed. How does that work in practice?
Yes, the disclosure letter. This is absolutely fundamental. It's a separate document prepared by the company and its lawyers, delivered alongside the subscription agreement. Its job is to make specific disclosures against the warranties. So, if a warranty says there is no litigation, the disclosure letter might say, except for the ongoing employment tribunal claim brought by X.
And the standard is fair disclosure. What does that mean?
It means the disclosure has to be clear, specific, and detailed enough that a reasonable investor, reading the warranty and the disclosure together, can properly understand the nature and scope of the issue being disclosed and its potential impact. Vague or boilerplate disclosures generally don't count as fair.
So the disclosure letter isn't just paperwork, it's a critical risk management tool for the company.
Absolutely. It forces them to systematically review the warranties and identify known issues.
And for investors, it's the final check on their due diligence.
Exactly. Did the company reveal everything they found? Are there new issues here? Investors and their lawyers scrutinize the disclosure letter very carefully. Diligent preparation by the company is vital. Thorough review by the investors is just as vital.
You mentioned the BVCA keeps updating warranties. What are some significant recent additions or changes?
Well, the big one generating buzz is the new suite of artificial intelligence AI warranties.
Right, AI specifically called out. What do they cover?
They get into things like the underlying AI technology, the data used for training its origin, quality, potential bias compliance with any relevant AI regulations or ethical guidelines, and related IP ownership. It's a direct response to AI becoming so prevalent and having unique risks.
So companies using or developing AI will face specific scrutiny here?
Definitely. They'll need to be prepared to give assurances in these areas during funding rounds. Another significant update reflects the changing regulatory landscape. Optional clauses dealing with the UK's National Security and Investment Act 2021, NSIA.
The foreign investment screening regime, how does that fit in?
These optional clauses basically require the company, and sometimes the founders, to cooperate with investors if the deal triggers an NSIA review or needs mandatory notification.
So investors want contractual promises of help navigating potential national security hurdles.
Yes. Seeing this in the BVCA model docs signals that NSIA risk is now a mainstream consideration in UK VC, not just a niche issue. It's very relevant for international investors, including those based in Luxembourg who might be investing in sensitive sectors. They want that cooperation baked in. We've also seen updates refining existing warranties, things like IP, business systems, data protection, just keeping them current with best practice. And new insolvency warranties were added, which is fairly standard investor protection.
It really shows how these models try to stay relevant to the current legal and commercial environment. Okay, so we've covered the subscription agreement, the document that seals the deal. Let's move to the one governing the relationship after the deal closes. The shareholders agreement, the SHA.
Right. This is the long-term rule book for how everyone interacts.
Who are the usual parties to the SHA?
Typically, it includes all the significant shareholders right after completion. So the new investors, any existing major shareholders, the founders, and almost always the company itself is a party too.
Why do you need this separate private agreement when you already have the public articles of association?
Good question.
Huh.
The SHA is a private contract, so unlike the AOA, it's not filed publicly. This lets you put more commercially sensitive or highly detailed arrangements in here. It regulates the relationship among the shareholders themselves and also with the company. It includes detailed rules on ongoing governance, decision-making processes, specific investor protections that might be too complex or just not suitable for the public AOA. It's really about balancing the different shareholders' interests over the life of the investment.
And it kicks in when the investment completes.
Yes, effective from completion. And as we said, new investors in later rounds typically just sign a deed of adherence, agreeing to be bound by the existing SHA.
What are the main things it covers? The real substance.
Key areas include investor consent rights, often called reserved matters or veto rights, rights to appoint directors or board observers, information rights, and very detailed rules around selling or transferring shares, including preemption rights, tag-along, and drag-along rights, plus various promises or undertakings from the company.
Let's look at those. Information rights, getting updates on the business.
Pretty standard, but vital for investors to monitor performance. Rights to receive regular management accounts, financial statements, budgets, business updates. Interestingly, a recent BVCA update added optional wording allowing the board, with consent, to potentially restrict or redact sensitive info shared with investors who might be competitors, a nod to protecting the company's competitive position.
Makes sense. Board representation and observer rights, getting a seat at the table.
Exactly. Lead investors often negotiate the right to appoint a director, an investor director. Other investors might get observer rights, the right to attend board meetings and get papers, but without a formal vote.
Now, the reserved matters list. The investor vetoes. This sounds like a major negotiation battleground.
Oh, it absolutely is. This list defines which fundamental company decisions cannot be made without specific investor consent, often defined as needing approval from an investor majority, a certain percentage of the investor shares, or sometimes the consent of the investor director.
What kind of decisions usually make the list?
Things like changing the articles, issuing new shares, especially if they rank equally or senior, taking on significant debt, major acquisitions or disposals, changing the core nature of the business, approving the annual budget, hiring or firing the CEO or other key execs, decided to wind up the company. It's usually a pretty extensive list.
So negotiating this list is basically negotiating the balance of power between management autonomy and investor control.
Precisely. Founders push for a shorter list to keep flexibility. Investors want a longer list to protect their investment from major changes they don't agree with.
What about rules on selling shares? Preemption rights.
If one shareholder wants to sell, the preemption clause usually gives the other existing shareholders a right of first refusal to buy those shares, typically pro rata, before they can be sold to an outsider. It helps keep the shareholder group controlled. Note: preemption on new share issues is usually in the AOA, but the SHA might add procedural details or waiver mechanics.
And tag-along and drag-along. Key for exits, you said.
Definitely. Tag-along protects minority shareholders. If a majority shareholder sells out, the tag-along right lets minority holders join the sale on the same price and terms, ensures they don't get left behind with a new majority owner they didn't choose. Drag-along is the flip side, benefiting the majority, often including investors. If a high percentage of shareholders, say 75%, often required to include the investor majority, agree to sell the whole company, they can force or drag the remaining minority shareholders to sell their shares too on the same terms. This is crucial for delivering a clean 100% sale to a buyer.
The SHA also covers governance and control beyond board seats.
Yes. It often specifies things like quorum requirements for board meetings, for example, needing the investor director present, and the detailed mechanics for getting consents for those reserved matters.
And director indemnification, is that common now?
It's become much more standard, yes. The BVCA model now includes optional clauses for the company to indemnify investor directors for liabilities incurred in their role. This is partly influenced by U.S. practice and reflects the global nature of VC, relevant if you're co-investing alongside U.S. funds.
Then there are the company undertakings, promises the company makes about how it will operate.
Correct. These are covenants, promises to do or not do certain things. Operationally, things like running the business properly, maintaining insurance, sticking to budgets, limits on spending or borrowing.
And you mentioned the BVCA has beefed up the compliance undertakings lately.
Yes, definitely an area of increased focus. Stronger covenants around anti-bribery corruption, ABAC, anti-money laundering, AML, anti-tax evasion, and sanctions compliance are now common. Often includes requirements to adopt formal governance and financial policies too.
It signals investors are demanding higher ethical and compliance standards much earlier on.
It really does. It's not just about the financials anymore. And reflecting global pressure, the models now explicitly include ESG undertakings.
ESG finding its way into standard VC docs. What kind of things?
Could be covenants relating to adopting a code of conduct, promoting diversity and inclusion, DEI, doing data protection audits, maybe even considering climate risks or having sustainability plans.
That's notable. Seeing it codified like this really connects with Luxembourg's focus on sustainable finance.
It absolutely does. And finally, specific to the UK context, you'll often see IC's undertakings, where the company promises to maintain its qualifying status for those crucial UK tax relief schemes. But importantly, these are often qualified as being subject to the director's overriding fiduciary duties.
Meaning directors can't jeopardize the company just to maintain tax status if it conflicts with their main duty.
That's the idea. It gives the board some protection if there's a conflict.
So quick recap on recent SHA updates. We had restricted disclosure for strategic investors, director indemnification.
The clarification on VC competing investment opportunities, which gives VCs operational certainty, very relevant for international funds.
And the drafting response to the Dinandage case on variation of share rights.
Yes, clarifying that exercising pre-agreed rights doesn't trigger an unexpected need for separate class consent, shows how the documents adapt to legal interpretations.
That interplay is fascinating. Okay, let's tackle the last core document, the Articles of Association, AOA, the company's public constitution.
That's the one. Arguably the most fundamental from a pure corporate law standpoint.
And it binds everyone, company and all shareholders.
Yes, legally binding on the company and all shareholders, present and future. It's treated as a statutory contract under the Companies Act 2006.
Why does it need such a major overhaul for a VC investment? Can you just use the standard ones?
No, the standard model articles for a private company are far too basic. The AOA must be significantly amended and restated for a Series A. This is where you embed the core rights of the new investor preference shares and the agreed governance structure directly into the company's legal DNA.
When does this happen? How is it approved?
Adopting the new AOA is usually a condition precedent to closing the investment. It requires a special resolution meaning a 75% majority vote of the existing shareholders. The new AOA is then filed publicly with Companies House within 15 days.
Public filing is key. anyone can see these.
Yes. Unlike the SHA, the AOA is on the public record. It's governed by English law and must comply with the Companies Act.
What are the most critical VC-specific clauses found in the AOA?
The share capital section is vital. It defines the different classes of shares, ordinary, Series A preference, etc., and spells out their specific rights regarding voting, full rights, limited rights, or no votes. Dividends, you issue a priority right to receive dividends first, and crucially, return of capital.
And return of capital is where the liquidation preference lives.
Exactly. This is a fundamental investor protection, hard-coded into the Constitution. It dictates the waterfall, the order of priority for payments if there's a liquidation event. That term is usually defined broadly to include not just winding up, but also a sale of the company or sometimes even an IPO below a certain threshold.
And the typical preference is 1x the investment back first.
For a standard UK Series A, yes, a 1x non-participating preference is common. This means the preference shareholders get their original investment back before any proceeds go to the ordinary shareholders.
Non-participating versus participating, can you clarify that again?
Sure. Non-participating usually means the investor gets the greater of either A, their preference amount, example, 1x investment, or B, the amount they'd get if they converted their shares to ordinary shares and shared pro rata in the total proceeds. Participating means they get A, their preference amount back first, and D, then they also share in the remaining proceeds alongside the ordinary shareholders as if they had converted. The BVCA models typically lean towards the non-participating greater of structure for early rounds. Recent updates have added clarity on calculation mechanics, especially involving different currencies.
Anti-dilution provisions are also in the AOA, another core protection.
Yes, absolutely. Also embedded in the Constitution. These protect existing investors if the company later issues new shares at a lower price per share than they paid a down round. The anti-dilution clause automatically adjusts the conversion ratio of the preference shares into ordinary shares, effectively giving the earlier investors more ordinary shares to compensate for the valuation drop.
And the common types, full ratchet versus weighted average.
Full ratchet is the harshest for everyone else. It resets the earlier investor's effective price down to the new low price, regardless of how many shares were issued. Weighted average is much more common and generally seen as fairer. It uses a formula considering how many new shares were issued at the low price relative to the total shares outstanding. The BVCA default is a broad-based weighted average formula. Updates have clarified how this works if investors came in at different prices, for example via convertible notes, and how the investors can waive the protection.
The AOA also covers conversion rights, when preference shares turn into ordinary.
Yes, it specifies how and when that happens. It can be optional at the investor's choice or automatic, usually triggered by a specific event, like a qualified IPO, an IPO meeting minimum size or valuation criteria.
What about the good and bad lever provisions? Are they primarily in the SHA or AOA?
The detailed definitions and the consequences, price paid for shares, are typically negotiated and set out in the private SHA. However, the AOA needs to contain the actual power for the company to compulsorily acquire or transfer shares held by levers. So they work together.
And the recent BVCA tweak on bad levers, making resignation not automatically bad.
Yes, the default drafting in the updated model AOA removed an optional clause that previously made simple resignation, unless constructive dismissal, an automatic bad lever event. It shifts the starting point slightly, but investors can, and often do, negotiate stricter definitions in the SHA. The overall goal is to ensure equity stays with active contributors and can be recycled if key people leave.
Let's revisit the variation of share rights issue and D to nudge. How did that affect the AOA specifically?
Well, the Companies Act requires a 75% vote of a specific share class to vary the rights attached to that class. The de nudge ruling was problematic because it said simply exercising a pre-agreed right in the articles, like a conversion right, could itself be deemed a variation needing a fresh class consent. This went against how everyone understood it worked.
So the BVCA had to fix the drafting in the AOA too?
Yes, both the SHA and AOA were updated. The revised drafting now explicitly states that taking actions provided for and permitted by the articles, or SHA, like converting shares or drag-along forcing a sale, is not considered a variation of class rights needing a separate Companies Act class consent. It aims to restore the original commercial understanding.
It really highlights how case law can ripple through standard documents in a common law system.
It's a perfect example. Advisors need to track both legislative changes and significant court decisions.
Any other key recent AOA updates from BVCA?
A really significant one is embedding robust sanction provisions directly into the articles.
Sanctions compliance in the company's constitution. Wow.
Yes. These clauses can prevent shares being allotted or transferred to sanctioned persons, give the board power to demand information about sanction status, and even force a transfer of shares held by someone who becomes sanctioned.
That gives the company very strong powers against any shareholder, overrides usual rights.
Potentially, yes. Putting it in the AOA makes it constitutionally binding on everyone and reflects the extreme seriousness of sanctions compliance globally, very relevant for Luxembourg entities operating internationally. Other updates included clarifications on calculating the liquidation preference, especially with currency conversions, and clarifying how anti-dilution works with different entry prices and investor waivers.
And that optional drafting on preemption for new issues, addressing minority concerns.
Yes, optional language added to potentially protect minority investors if the majority wants to waive preemption rights on a new funding round, though the BVCA flags this could add complexity later on.
Okay, we've dissected the 4 core documents. How do they actually function as a coherent whole? What's the hierarchy? And how do lawyers prevent conflicts?
All right, think of it as layers. At the very top, you have the mandatory provisions of the UK's Companies Act 2006. You can't contract out of those.
Then the Articles of Association.
The AOA is the company's constitution, binding on the company and all shareholders, and it's public. Generally, if there's a direct conflict between the AOA and the SHA on a matter of core company law or capacity, the AOA will prevail because it's the formal constitution.
And the shareholders' agreement sits alongside it.
Exactly. The SHA is the private contract between the parties. It supplements the AOA, adding more detail, especially on governance and commercial arrangements.
And the subscription agreement triggers entry into this structure.
Precisely. It governs the investment event itself, bringing the new investors into the company structure defined by the AOA and governed by the SHA. The term sheet was the initial guide for drafting all 3. So the hierarchy is roughly Companies Act, AOA, SHA. But crucially, a well-drafted SHA will usually contain a supremacy clause or further assurance clause. This contractually obliges the parties to say that if there is an inconsistency, they will use their voting rights, where legally possible, to amend the AOA to match the SHA.
So you try to ensure the private agreement ultimately drives the public one within limits.
That's the goal. It requires careful legal drafting to ensure consistency across all documents. Definitions must align, cross-references need to be accurate, and the intended hierarchy should be clear to avoid ambiguity and ensure the commercial deal is fully enforceable.
Does the BVCA separating the sub-ag and SHA help with consistency?
It does help with clarity and management over time. The sub-ag handles the snapshot of the investment, while the SHA focuses purely on the ongoing relationship rules, making it easier to add new investors later without muddying the waters.
Okay, great overview of the structure. Now, despite these standard models, you stress negotiation is vital. What are the typical key negotiation areas in a UK Series A? Where do founders and investors usually lock horns?
Absolutely. The models provide the framework, but the key commercial terms within that framework are always up for grabs, depending on leverage and the specific deal. Negotiation generally centers on 4 main themes: valuation, economics, control, and exit.
Let's start with economics. Setting aside the headline valuation itself, what gets debated?
Liquidation preferences are huge. Is it a standard 1x non-participating preference? Or are investors pushing for more, a higher multiple, or participating rights? Founders will fight hard against participation because it eats into their upside on exit. Anti-dilution terms are another battleground. Founders want the least punitive version, usually broad-based weighted average, while investors might push for narrow-based or even full ratchet if the market is tough. Negotiating carve-outs from anti-dilution, like for employee option pools, is also standard. Dividend rights are defined, but actual cash dividends are rare early on.
What about control and governance?
Board representation is key. How many seats do investors get? What's the total board size? Founders usually want to maintain majority control if possible. Then the big one: the precise list of reserved matters requiring investor veto. Founders want this list short for operational freedom. Investors want it long for maximum protection of their investment against key decisions going sideways. Scope and frequency of information rights are also negotiated.
Are there points specific to the founders themselves that get negotiated hard?
Oh, yes. Founder vesting, how their existing shares vest over time, typically 3 to 4 years with a 1-year cliff before anything vests. Acceleration of vesting on certain events, like a sale, is also negotiated. Tied to this are the good and bad leaver provisions. The definitions here are critical. What exactly constitutes a bad leaver? E.g., misconduct, breach of contract, versus a good leaver, e.g., death, disability, termination without cause. And what happens to their shares? Forced transfer at nominal value for bad leavers, fair value for good leavers. These are super sensitive and crucial for aligning incentives and managing equity. Key terms of founder service agreements are also agreed.
And going back to the subscription agreement, the warranties and liability limits?
Always negotiated. The scope of the warranties themselves, are they qualified by materiality or the founder's knowledge? And crucially, the limitations on liability. Investors want high caps, long time limits for claims, low thresholds. The company, and founders, if warranting, want the opposite: low caps, short time limits, high thresholds to minimize their potential exposure.
You mentioned the company typically pays investor legal fees. Is the amount negotiated?
Yes, absolutely. While the principle of the company covering reasonable investor legal fees is standard, the cap on that liability is a key negotiation point for founders. They want to limit how much of the investment money immediately goes out the door on fees.
What about exit provisions in the SHA?
The threshold for triggering the drag-along right, what percentage of shareholders needs to agree to force a sale, and any specific conditions around it are negotiated. Procedural aspects of tag-along rights are also reviewed.
What factors tend to drive up the costs of a deal? Legal fees mainly.
Legal fees are a big part, yes, but complexity of the deal structure, how well prepared the company is, a clean data room saves huge amounts of time and money, how protracted the negotiations become, the choice of law firms and their rates, how effectively the muscle documents are used or deviated from, and specific requirements from investors all play a role.
So even starting with BVCA models, you expect to see bespoke amendments.
Always. They're a template, not a straitjacket. Deals involve tailoring. Maybe investors push for participating preference in a riskier deal. Founders negotiate to narrow the reserved matters list, liability caps get adjusted, leaver definitions are refined, and what's considered market standard evolves. If certain amendments become very common in practice, you might see them incorporated into the next BVCA update. So advisors need to track both the models and current market trends in negotiation.
Okay, let's walk through the practical process and timeline. How does a typical UK Series A unfold from start to finish?
Right. It usually starts long before lawyers get heavily involved, with the company doing its preparation business plan, financials, pitch deck, and crucially, setting up a well-organized virtual data room. Then comes investor outreach and pitching.
If you get traction, you move to term sheet negotiation and signing.
Exactly. Often includes an exclusivity period locking the company into negotiating only with that investor for a while. Signing the term sheet kicks off the formal due diligence, legal, financial, commercial, technical, where investors and their advisors pour over the data room.
And the DD findings directly impact the next stage.
Absolutely. Issues found in DD feed straight into negotiating the warranties in the subscription agreement and what needs to go into the disclosure letter.
Which brings us to the definitive document drafting and negotiation stage.
Yep. Lawyers for the company and the lead investor draft and haggle over the subscription agreement, SHA, AOA, and the disclosure letter. This usually runs in parallel with the final stages of DA.
Once docs are agreed, any conditions precedent need ticking off?
If there are any, yes. They must be satisfied or formally waived before you can move to the final step. Closing or completion.
What actually happens at closing?
It's the culmination. All the final documents are signed and dated. The investment funds are wired to the company's bank account. The company's board formally approves the allotment of the new shares, and any other agreed corporate actions, like appointing new directors, happen. Then the post-completion admin, like filings, begins.
What sort of timelines are we looking at? Is it quick?
Quick is relative in legal deals. It varies enormously. From starting serious talks to closing might be anything from, say, 2 months to 6 months or even longer. Just focusing on the period from signing the term sheet to closing, a realistic target for a reasonably straightforward Series A using BVCA docs might be 4 to 8 weeks. But delays are common.
What causes deals to drag out longer than expected?
Lots of things. Poor company preparation. A messy data room is a classic time killer. Unexpected findings in due diligence. Protracted negotiations on key points. The number of investors involved, coordinating a syndicate takes time. Simple unresponsiveness from parties or their lawyers. Inability to resolve final commercial sticking points. Using model docs helps streamline drafting, but it doesn't magically solve negotiation hurdles or poor preparation. Managing expectations on timing is important.
We touch on costs. Legal fees can be substantial, and the company usually pays both sides. What's a typical range?
It really varies. For a very clean, simple Series A, using models efficiently, maybe £15,000, £30,000 per side isn't unusual. For a complex, heavily negotiated round with multiple investors, it could easily be 50,000, 100,000 plus per side. So the company could be looking at 30K to over 200 pound K in total legal fees coming out of the round.
Which underlines why negotiating that cap on investor fees is so important for the company.
Absolutely crucial for preserving capital. And remember, other factors like deal complexity, negotiation intensity, choice of law firm all impact the final bill.
Are there other fees investors might charge beyond legal costs?
Sometimes, though less common in pure VC Series A, you might see a one-off arrangement fee, a percentage of the investment, often deducted from the funds, or maybe ongoing annual monitoring fees, more typical in later stage private equity, but worth asking about.
Okay, deal done, money's in. What about the mandatory corporate actions and filings afterwards? The legal housekeeping.
Essential stuff can't be skipped. The company needs formal board resolutions approving the final documents, authorizing the share allotment, appointing new directors, etc.
And shareholder resolutions.
Yes, needed for key changes, usually done by written resolution in private companies. You need shareholder approval, typically special resolutions needing 75% for things like giving the directors authority to allot the new shares, disapplying statutory preemption rights, so share can be offered directly to the investors, and formally adopting the new articles of association.
Then the filings with Companies House, the public record.
Mandatory, with strict deadlines. Key ones are Form SH01, return of allotment, within 1 month. Filing a copy of the newly adopted AOA within 15 days. Filing copies of any special resolutions within 15 days. You also need to update the company's register of persons with significant control, PSC, and notify Companies House of any changes, like new shareholders crossing ownership thresholds or new directors.
And you mentioned new ID verification rules coming.
Yes, under the ECCTA 2023 Act. Mandatory identity verification for directors and PSCs is being phased in from autumn 2025. It adds an extra administrative step for companies and their officers, very relevant for Luxembourg entities with UK operations or investments.
And finally, updating the company's own internal books.
Yes, the company must update its internal statutory register of members, directors, share allotments, PSC register, typically within 2 months of the share allotment.
Right, this is a perfect point to focus on specific considerations for Luxembourg legal professionals dealing with these UK deals. Understanding UK tax advantage schemes like EIs and Cs seems critical context.
Absolutely essential context, yes. The Enterprise Investment Scheme, EIS, and the Seed Enterprise Investment Scheme, EIS, are UK government initiatives. They aim to boost private investment into smaller, riskier UK trading companies by offering really quite generous tax reliefs to qualifying individual investors who are UK taxpayers. The Cs is for the very earliest stage, EIs for slightly larger early-stage companies.
What kind of tax benefits do UK investors get?
Significant ones. Things like upfront income tax relief, 30% for EIS, 50% for size, up to certain investment limits. Capital gains tax, CGT exemption on profits when they sell the shares if held for 3 years. Loss relief if the investment fails, can offset the loss against income or other gains. And CGT deferral for EIS or reinvestment relief for size, allowing them to defer or reduce tax on other gains.
So these schemes dramatically change the economics for UK individual investors.
Hugely. They significantly de-risk the investment from a tax perspective and boost potential net returns. It makes investing in qualifying companies far more attractive for them.
And the companies themselves must meet strict criteria.
Yes, very strict rules apply regarding the company's size, age, independence, the nature of its trade. Must be a qualifying trade. Many financial or property activities are excluded. Having a UK presence, and limits on how much ICES funding it can raise in total. Companies often seek advance assurance from HMRC, the UK tax authority, confirming they likely meet the criteria, which gives investors comfort.
How does this filter down into the legal documents we've discussed?
Directly. You'll see specific warranties in the subscription agreement confirming the company currently qualifies. You'll find detailed undertakings in the SHA where the company promises to operate in a way that maintains its qualifying status and doesn't jeopardize the investor's tax relief. Though, as noted, these are subject to directors' fiduciary duties. You might even see optional specific clauses in the AOA related to how liquidation preferences interact with EIS rules. The key takeaway for Luxembourg professionals is this. Understanding ICES explained why certain operational covenants or structural points are absolute deal breakers for UK individual investors. Maintaining that tax status is often paramount for them, driving specific documentation requirements.
Okay, widening the lens again. What are some key high-level differences in legal approach between UK common law VC practice and what might be familiar in Luxembourg's civil law system?
Well, the source of law and interpretation is fundamental. UK common law relies heavily on precedent from case law, often takes a literal approach to interpreting contracts, and has that limited role for implied good faith we discussed. Luxembourg civil law is based on comprehensive statutes, codes, considers the parties' subjective intentions more, and generally accepts an implied duty of good faith.
What about standardization of documents?
The UK has the widely adopted BVCA models, providing significant standardization for VC. Luxembourg has very flexible corporate structures like the SCSP, which is popular and mirrors Anglo-Saxon LPs, but perhaps less of a single, universally adopted standard document suite across the whole market.
And investor protections themselves. Are the concepts similar?
Many core concepts: liquidation preferences, anti-dilution, board seats, veto rights, information rights, are pretty global in VC now. The differences lie in the mechanics and emphasis. The UK system places huge weight on extensive warranties and the formal disclosure process. The precise drafting of rights in the AOA versus the SHA is also a UK common law feature. Luxembourg practice will have its own conventions for documenting similar rights within Lux corporate structures, SARL, SA, SCSP, and their specific legal requirements.
The role of notaries is another difference.
Yes, typically less involvement in standard UK private company share issues or AOA changes compared to Luxembourg, where notaries are often required for key corporate acts like incorporation or amending articles for certain company types.
And that good faith point again.
Worth reiterating. The general lack of a broad implied duty in UK commercial contracts means you must rely on explicit terms, contrasting with the position in many civil law systems.
And dispute resolution.
Remedies for breach of SHA are contractual in the UK. Breaches of director duties or shareholder disputes, like unfair prejudice claims, follow specific statutory paths under the Companies Act. Luxembourg has its own distinct procedures under Lux company law for resolving shareholder disputes. So while the commercial aims of a VC deal are often the same, the legal frameworks, documentation styles, and procedural nuances differ significantly. Advisors need to bridge that gap in cross-border deals.
Which leads perfectly to the final point: choice of law and jurisdiction when UK and Luxembourg parties are involved.
Critical to get right. If you're investing into a UK company, the core investment agreements SUBAG, SHA, AOA will almost certainly be governed by English law. The company operates under English law. The BVCA models are English law-based.
Even if the investor is a Luxembourg fund or vehicle?
Yes. The Luxembourg vehicle's own internal governance documents might be Lux law, but the contracts governing its investment into the UK target company will be English law. While parties have some freedom, English law mandatorily governs aspects of the UK company's constitution and capacity anyway.
And where do disputes get heard? The jurisdiction.
That's agreed in the contracts. Common choices are the English courts, chosen for commercial expertise, established case law, seen as impartial; arbitration, increasingly popular for cross-border deals due to neutrality, confidentiality, flexibility, and global enforceability under the New York Convention; London is a major seat, using rules like LCIA or ICC; or potentially the Luxembourg courts, perhaps if the dispute centers more on the Lux vehicle itself or if parties prefer a civil law forum. Clear, unambiguous drafting of the governing law and dispute resolution clauses specifying court jurisdiction or the arbitration seat rules is vital. Choosing depends on factors like perceived neutrality, expertise, procedural differences. Just for example, disclosure discovery rules vary hugely between England and civilized systems, available remedies, and cross-border enforcement.
And for Luxembourg advisors, managing that interface between the Lux law governing the investment vehicle and the English law governing the UK investment itself is key.
Exactly. Making sure the two layers mesh correctly is crucial.
Well, that's been an incredibly thorough journey through UK VC documentation using the BVCA framework, specifically aimed at giving our Luxembourg audience practical insights. We've covered the landscape, the core documents, key concepts, the process, negotiation flashpoints, and those vital cross-border considerations like tax schemes and legal system differences.
And the key takeaway is that it's a sophisticated but also dynamic framework. The BVCA keeps it updated, market practice evolves, so staying current is really non-negotiable for advisors in this space.
Absolutely. It's a system designed for standardization but demanding bespoke negotiation, all within a common law context shaped by ongoing case law. Understanding that whole picture is vital. If you had to pick one single point for a non-UK advisor to really focus on from this whole suite, what would it be?
That's tough. But I think I'd go back to the interaction between the extensive warranties and the crucial process of fair disclosure via the disclosure letter. It's such a central mechanism in UK deals for allocating risk based on due diligence findings, and the process and standards might feel quite different compared to practices rooted in civil law. Getting that right, both giving and receiving disclosure, is fundamental to managing risk in a UK VC investment.
A really practical point to end on. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.